Greetings, loves, greetings. Welcome back to Soul Search and welcome to Soul Search. If this is your first time here, guys, make sure you click that like button. Make sure you subscribe if you haven't already subscribed. And make sure you click that notification bell. So I now have my microphone together, okay? And I also have this up on the big screen. I am showing you guys the court documents here as I read them off through my phone, is where you'll be seeing it. So I'm pretty sure it's going to be pretty small. You can stop, pause, enlarge, take a screenshot, whatever you need to do in order to see if you want to see anything, right? So we left off on page 8, guys, and this is Miss Tracy, okay? And Miss Tracy, if you guys don't remember, she is Sandra Tracy, okay? And she is suing Thornton Township. She's suing Tiffany Henyard. She's suing Keith Freeman. And she is suing Robert Hunt, okay? All right. So we're going to go back to page 8. And I'm going to read page 8 again, just so that we can all, catch up and be on the same page. And make sure everything's plugged up. I don't want anything to die, okay? All right. So, page 8, number 38. Now, as Tracy was required to provide her work hours along with a report of work that was done for Freeman's approval, even though Freeman had completely stopped communicating with her after June 7th of 2022. Freeman failed to acknowledge or even respond to the emails. Now, prior to her FMLA leave, Tracy had been a member of the South Suburban Economic Development Corporation, that is SSEDC, and it is a steering committee in a countrywide initiative to expand and improve adequate housing resources for employees of major employers in the region. Okay? So, on June the 21st, SSEDC sent Tracy an email regarding the steering committee. A committee meeting was convened to address critical issues regarding initiatives being created. So Tracy responded by inviting SSEDC Consortium Chair to connect with Township Management, Freeman and Hunt, to get direction on the Township's continued participation in the consortium, since no one from Thornton Township Management was speaking with Tracy after her FMLA return. Now, after Tracy responded to the SSEDC, Freeman and Henyard scolded Tracy for her unprofessional and unauthorized emails to SSEDC. Now, between June 25th of 2022 and August the 12th, Tracy began sending emails to G. Gonzalez, the township payroll coordinator, detailing her hours worked. Now, Tracy was then instructed to begin manually punching in a time clock in the township office building, despite being locked out. In order to do this, Tracy had to sneak into the building and punch in and sneak back in to punch out. Okay, every instance that Tracy snuck in and out of the building, it led her to feeling tremendous anxiety of retribution if she was caught inside. Now, beginning August 1st of 2022, Freeman stopped approving Tracy's time card, resulting in a loss of pay. Okay, that's where we left off. So we're now going to go to page 9. Okay. So from August 1st of 2022 through September 14th of 2022, Thornton Township failed to pay Tracy. Now, the township's failure to pay Tracy was highly consequential and detrimental to her mental health and well-being. Tracy provides full support for her husband, who has been seriously ill for years and is near terminal. The lack of pay was devastating to TRACY. Furthermore, during this time, TRACY could not even collect unemployment compensation due to still being employed by the township. On August 14th of 2022, due to the stress of dealing with the circumstances surrounding her employment and lack of pay, TRACY suffered a myocardial infarction, which is a heart attack. On September the 6th of 2022, after being fed up with what was happening at work, TRACY sent an in-depth email to Freeman inquiring as to why she was being ignored, mistreated, and not paid. Freeman did not respond. Now, on or about September the 9th, 2022, TRACY sent the email to Freeman, Hunt, and Anthony Butler, who is the HR intern, demanding to be paid per Illinois Department of Labor, wage, and hour laws. In response to her email, TRACY was referred to the township attorney, James G. Cecil, of the Delgado law firm. Now, upon information and belief, on September the 13th of 2022, in closed doors meetings with the Board of Trustees, Henyard decided to terminate TRACY. Upon information and belief, Henyard lied to the Board of Trustees in this meeting and said that TRACY was aware of her impending termination beforehand. On September the 14th of 2022 at 12:51 a.m., TRACY received an email from James G. Cecil, Township Attorney, that her employment had been terminated with no other information. Now, in response thereto, TRACY sent a response email back requesting a due process hearing. However, TRACY never received a response. As such, TRACY was terminated without pre- or post-termination hearings. Now, while employed with Thornton Township, TRACY was a dedicated employee. She enjoyed the work she did, and she planned to stay with Thornton Township for the remainder of her career. TRACY had worked hard to earn and maintain a good personal and professional reputation as a public servant, and as a result enjoys a good personal and professional reputation as a public servant to the community. As a result of the termination at the hands of the defendants, TRACY suffered humiliation, shock, and grief, as well as emotional, reputational, and economic harm. So we have count 1, violation of the Family and Medical Leave Act against Thornton Township, Henyard, and Freeman. Now comes the plaintiff, Sandra TRACY, by and through her attorneys, for her complaint against defendants, Thornton Township, Tiffany Henyard, individually and in her official capacity, and Keith Freeman in his individual and official capacity, for a violation of the Family and Medical Leave Act, and in support thereof states and alleges as follows. TRACY restates and realleges paragraphs 1 through 61 as though fully set forth herein. The Family Medical Leave Act, the FMLA, allows an eligible employee with a serious health condition that renders the employee unable to perform his or her position to take 12 work weeks of leave during each 12-month period. Okay? So Thornton Township qualifies as an employer, as that term is defined in the FMLA because it is a public agency. TRACY is an eligible employee as that term defines. 1 second, guys, I lost my page. All right, let me me get it back. Sorry about that. Just trying to scroll up. Okay, Tracy is an eligible employee as that term is defined in the FMLA because Tracy worked for Thornton Township for at least 12 months and 1,250 hours of service with Thornton Township. During the previous 12-month period, before she took the FMLA leave on February the 28th of 2022. Now, Tracy had an entitlement to leave, i.e., she was eligible for FMLA protections, as defined in the FMLA, because of a serious health condition that made Tracy unable to perform the functions of her position with the Thornton Township. Tracy properly requested to leave from Thornton Township in October 2021. Now, this request for leave was supported by a certification issued by Tracy's health provider. It was a certification which was provided to Thornton Township in a timely manner and which was sufficient pursuant to, and there's a code, 29 U.S.C. 2613B. So Tracy provided sufficient notice of her intent to take leave by sending emails to Frank M. Zuccarelli, the then supervisor of Thornton Township, in October 2021. Now, Tracy was granted FMLA leave on or about February 28, 2022 through on or about June 1st of 2022. As such, Tracy was entitled to take leave under the FMLA due to Tracy being eligible for the FMLA protections based on her disability and for giving proper notice to Thornton Township of her request because Thornton Township approved Tracy's request. Okay, let me try to catch you guys up here because I'm reading from my computer, but you're looking at it on my phone. Okay, so it might be a little slow keeping you on the same page as me, but I'll make sure you get to see everything. Alright, so accordingly, Tracy was entitled to be restored either to the same position held at her time of leave or to an equivalent position with equivalent employment benefits, pay, and other terms and conditions of employment upon her return. Now, if you guys remember, we read earlier that they reduced her position but told her that all her benefits will remain the same, except, again, her position, the position itself was reduced. Therefore, she was in a much lesser position. They said her pay and benefits would remain the same, but of course, she would no longer have any access to pretty much everything that she previously had access to. Okay. So it says, however, Thornton Township interfered with, restrained, and or denied the exercise of or the attempt to exercise Tracy's fundamental FMLA rights by not restoring Tracy back to her job pre-FMLA leave, not restoring her same pay, benefits, terms, and conditions of employment, and untimely terminating her employment upon return. So from what I've read, they told her her pay would remain the same, but of course, as it states here, she didn't even get her pay and wasn't allowed to properly clock in, clock out, and even when they were accepting her time, for a short amount of time in a different way, they stopped doing that. So she stopped getting paid. So basically, they didn't restore her same pay. They didn't honor her as an employee at all and even allow her proper access to do her job. So, upon returning from FMLA leave, TRACY was demoted from HR department manager to HR clerk on equal footing with an intern. TRACY had her office taken away and was forced to work in her car in the township parking lot, meet with coworkers outside if she needed to speak with them, was unable to access critical information to perform her job, and was unable to clock in and out of work in a manner consistent with before taking her FMLA leave. While TRACY's compensation rate technically did not change upon returning from her FMLA leave, she was not paid from August 1st, 2022 until September the 14th, 2022, a mere 2 months after returning from her FMLA leave. So by demoting TRACY on June 7, 2022, defendants denied TRACY restoration to the same or equivalent position as prescribed in FMLA. By making TRACY work out of her car, restricting access to the building, the coworkers, and necessary HR functions, and by not paying TRACY for 6 weeks upon her return from leave, defendants failed to restore TRACY to an equivalent position with equivalent employee benefits, pay, and other terms and conditions of the employment. As the result of TRACY's termination, TRACY had incurred and is now incurring and will continue to incur a loss in wages, salary, employment benefits, and other compensations denied or lost to TRACY by reason of the violation within the meaning of the FMLA in an amount to be proved at trial. Now, these costs include but are not limited to lost wages and medical expenses during TRACY's leave of absence, back pay from the effective date of termination, lost medical expenses from the date of termination, and lost employment benefits from the date of termination, the loss of front pay as of the date of this complaint, and any interest on the amount therein as provided in the FMLA, as well as attorney's fees. Okay. Sorry, I lost my place trying to scroll up for you guys. Okay. Medical expenses from the date of termination and loss of employment benefits from the date of termination, the loss of front pay as of the date of this complaint, and any interest on the amount therein as provided in the FMLA, as well as attorney fees and court costs. So the defendants will be unable to show that TRACY would not have been entitled to her position even if she had not taken leave. Wherefore, plaintiff Sandra TRACY respectfully requests that the judgment be entered against defendants Thornton Township, Tiffany Henyard, individually and in her official capacity, Keith Freeman in his individual and official capacity, and that this honorable court award her, for the following: back pay in amount to be determined at trial, compensatory and consequential damages including for emotional distress, get 'em girl, liquidated damages in pursuant to 29 U.S.C. 2617, sections A1 and A4. Punitive damages, prejudgment and post-judgment interest at the highest lawful rate. Attorney's fees and costs of this action, and any such further relief as this honorable court finds reasonable. Okay, so count 2. The 14th Amendment, retaliation, under 42 U.S.C. 1983, denial of procedural due process against all defendants. Now comes the plaintiff Sandra Tracy by and through her attorneys for her complaint against the defendants, Thornton Township, Tiffany Henyard, individually and in her official capacity, and Keith Freeman in his individual and official capacity, and Robert Hunt in his individual and official capacity for a violation of 42 U.S.C. 1983, a violation of Tracy's 14th Amendment due process rights, and in support thereof states and alleges as follows. Tracy restates and realleges paragraphs 1 through 77 as though fully set forth herein. Okay, so we're in paragraph 78. As a public employee, Tracy was entitled to both pre-termination hearing, a pre-termination hearing prior to her termination, as well as a post-termination hearing after her termination. Now, this pre-termination hearing is an initial check against mistaken decisions, essentially, a determination of whether there are reasonable grounds to believe that the charges against the employee are true, and support of the proposed action. Okay, paragraph 79. Okay, as public entity prior to the termination must provide oral or written notice of the charges against the employee, an explanation of the employer's evidence, and an opportunity to present her side of the story. Now, Tracy was denied a pre-termination and a post-termination hearing and was not given an opportunity to present her side of the story. Tracy's constitutional injury, her termination, was caused by persons with final decision-making authority, Freeman as village administrator and Henyard as mayor, and Hunt as HR manager and as Tracy's supervisor. See how they all have these double jobs? Wherefore, plaintiff Sandra Tracy respectfully requests that judgment be entered against the defendants, naming everybody again, individually and in their official capacities, right? Asks that this court award her the following grief. Okay, that is back pay in the amount to be determined at trial, compensatory and consequential damages including for emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rate, attorney fees and costs of this action, an injunction and order permanently restraining Thornton Township and its officers, agents, successors, employees, and our representatives, including the individually named defendants, from engaging in such further unlawful conduct and employment practices, including the policies and practices complained of herein. Any such further relief as this honorable court finds reasonable. Okay, that was count 2. Now we're moving on to count 3. Common law retaliatory discharge against all defendants. Now comes this plaintiff, Sandra Tracy, by and through her attorneys for her complaint against the defendants, naming everyone again in their individual and official capacity, right? Allege as follows. Tracy restates and re-alleges paragraphs 1 through 81 as though fully set forth herein. We are now on paragraph 82. Illinois has clearly mandated public policy in favor of protesting the illegitimate policies and practices of a government agency. Illinois has also a clearly mandated public policy in favor of employers legally and adequately paying their employees under Illinois minimum wage law. Likewise, Illinois and the United States have clearly mandated public policies in favor of protecting employees' rights under the FMLA and the Fair Labor Standard Act, which is the FLSA. Okay. Defendants discharged TRACY on September 14, 2022. Defendants discharged TRACY in retaliation for activities in support of the public policies in favor of reporting employers' illegal payment schemes after TRACY sent an email to Freeman and Hunt demanding to be paid per Illinois Department of Labor wage and hour laws on September the 9th, 2022. Defendants' act of discharging TRACY in retaliation for her comments about the Illinois Department of Labor and wage and hour laws and Thornton Township not paying TRACY for work she had already performed violates the clearly mandated public policies in favor of reporting employers' illegal payment schemes of its employees. TRACY's demotion and termination was, no doubt, in retaliation for TRACY 1. Taking FMLA leave, 2. Failing to acquiesce to Henyard's request to assemble a list containing the quote-unquote dirt on Dolton Township employees, complaining about not being paid under Illinois Department of Labor and Wage and Hour laws. Illinois has a clearly mandated public policy in favor of preventing retaliatory acts occurring in the workplace, which at all times herein applied to Thornton Township. That's page 15 of 24 pages, okay? So now we're on page 16. We're at paragraph 90. Thornton Township discharged TRACY in retaliation for activities in support of the public policies listed above. TRACY has suffered a loss of income and significant emotional distress as a result of the defendant's retaliatory acts. Wherefore, plaintiff Sandra TRACY respectfully requests that judgment be entered against the defendants, naming everyone again, okay, and that this court award, it says him, but we know it means her, the following relief. Again, back pay in amount to be determined at trial, compensatory and consequential damages, including for emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rate, attorney's fees and costs of this action, an injunction and order permanently restraining Thornton Township and its officers, agents, successors, employees, and our representatives, including the individually named defendants, from engaging in any such further unlawful conduct and employment practices, including the policies and practices complained of herein, and any such further relief as this honorable court finds reasonable. Okay, same requests made for so far 3 different counts. Okay, so that's so far 3 different judgments requested. Okay, count 4, the violation of the Fair Labor and Standards Act against all defendants. Now comes the plaintiff Sandra TRACY buying through her attorneys for her complaint against the defendants, naming everyone again, for their violation of the Fair Labor Standards Act. Now, and in support thereof states and alleges as follows. TRACY restates and realleges paragraphs 1 through 91 as fully set forth herein. Okay, We are now on paragraph 92. At all times relevant herein, the FLSA applied to Tracy's employment with Thornton Township. Okay, make sure we're still recording, and we are. All right, we're on paragraph 93, page 17 of 24. Thornton Township is an employer as defined by the FLSA, and Henyard is an employer defined by the FLSA. Because she is a person acting directly or indirectly in the interest of an employer in retaliation to an employee. Freeman is an employer as defined by the FLSA because she is a person acting directly or indirectly in the interest of an employer in retaliation to an employee. Now we have Hunt, who is an employer as defined by the FLSA because he is a person acting directly or indirectly in the interest of an employer in retaliation to an employee. Tracy is an employee as defined by the FLSA. Look at this lawyer doing their job. Defendants' willful failure to pay Tracy between August 1st of 2022 and September the 14th of 2022 violates the FLSA. And they have the statute code there. As direct and approximate results of this unlawful practice, Tracy suffered and continues to suffer wage loss and is therefore entitled to recover unpaid wages, liquidated damages, or prejudgment interests, attorney fees and costs, and such other legal and equitable relief as the court deems just and proper. Might I add, I believe this also covers now, okay, because she should still be an employee, so she is still losing wages that she should be earning. Okay, continuing. Wherefore, plaintiff Sandra Tracy respectfully requests that the judgment be entered against the defendants. Okay, we know who it is: Thornton Township, Tiffany Henyard, Keith Freeman, and Robert Hunt in their individual and official capacity. Okay, back pay in the amount to be determined at trial, compensatory and consequential damages for including emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rate. Page 18, attorney's fees and costs of this action, any such further relief as this honorable court finds reasonable. We are on count 5, guys. Conspiracy under 42 U.S.C. 1983 against all defendants. Okay. And now comes plaintiff Sandra Tracy by and through her attorneys for her complaint against the defendants. We know who they are: Thornton Township, Tiffany Henyard, Keith Freeman, and Robert Hunt in their individual and official capacity for civil conspiracy under 42 U.S.C. 1983, and in support thereof states and alleges as follows. Tracy restates and realleges paragraphs 1 through 99 as though fully set forth herein. We are now on paragraph 100. Tracy was deprived of her constitutional rights when her employment was terminated without due process. Defendants made an agreement to deprive Tracy of her constitutional rights. There was an actual deprivation of her rights arising from overt acts and furtherances of the agreement. Thornton Township has a well-settled and widespread policy of retaliation against employees for their speech and/or associations, terminating the employment of employees if they posed any kind of perceived political risk to Henyard. At least several other former Thornton Township and Village of Dolton employees besides TRACY have been terminated by Henyard and Freeman for similarly dubious and spurious reasons within the last few years, including but not limited to Jessica Jones, Stephanie Wildman, Lavelle Redmond, Karen Johnson, Bruce Owens, Mario Vaughn, Cheryl Collins, and Samisha Williams. Wow. I guess I need to look and see if I can see court documents or a case listed on these people, because for them to be mentioned here, I'm assuming they have a case, because it can't just be hearsay. Like, if you ever read or listened to someone read the court documents in some of Diddy's cases, you'll notice that one defendant will name another in a separate case. Like, say, Cassie, we know about her case, right? She, I can't remember who, but she mentioned, I think, one or more other defendants who have cases against them. And then when you get to, I think Rob is his name, I think we all know about that one, he mentioned other defendants that have a case, including Cassie. Okay, so wherefore plaintiff Sandra TRACY respectfully requests that the judgment be entered against the defendants. We know who they are, okay? And she is also requesting for count 5, back pay and amount to be determined at trial, compensatory and consequential damages, including for emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rate, attorney's fees, and costs of this action. They got it right? Sure they do. All that money they're getting paid, plus the money they're funneling, I don't know what they're doing with it, but what do their houses look like? Like, what's going on? An injunction in order permanently restraining Thornton Township and its officers, agents, successors, employees, and our representatives, including the individually named defendants, from engaging in any such further unlawful conduct and employment practices, including the policies and practices complained of herein. Any such further relief as this honorable court finds reasonable. Okay, we have count 6, page 19 of 24. And this is common law intentional infliction of emotional distress against all defendants. Okay. TRACY restates and realleges paragraphs 1 through 104 as fully set forth herein. Defendants conducted, described above, such demoting TRACY after taking FMLA leave, making her work in the parking lot, failing to pay her for over 6 weeks, and terminating her employment after complaining of not being paid, was truly extreme and outrageous and goes beyond all possible bounds of decency. Yes, it does. Look at this lawyering. Additionally, defendants committed these acts while acting in a position of authority of TRACY, which makes the acts de facto extreme and outrageous. And the relevant case is McGrath versus Fabi, 126, and they have the date and all the necessary case information listed there. All right, so we are now on page 20. Okay, paragraph 107. Defendants either intended that their conduct would inflict severe emotional distress or knew that there was at least a high probability that their conduct would cause severe emotional distress when they retaliated against TRACY. A defendant in the tort case must take its plaintiff as he finds her, even if she is more susceptible to injury than the average person. Relevant case, Zurba versus United States. Reed versus Union Pacific Railroad Company. Colonial Inn Motor Lodge Incorporated versus Gay. Okay, those are all the mentioned cases. And she is requesting back pay and amount to be determined at trial, compensatory and consequential damages, including for emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rates, attorney fees and costs of this action, and any such further relief as this honorable court finds reasonable. Count 7. The Illinois minimum wage law against Thornton Township. Get 'em, girl. Okay. TRACY restates and realleges paragraphs 1 through 108 as though fully set forth herein, and we are on paragraph 109 at the end of page 20. At all times relevant herein, IMWL applied to TRACY's employment within Thornton Township. Okay, and that is the Illinois minimum wage law. IMWL is the Illinois minimum wage law. Okay, page 21, and this is paragraph 110. All right, Thornton Township as an employer under the IMWL. TRACY is an employee under the IMWL, and from August 1st, 2022 through September 14th, 2022, TRACY was supposed to have been paid her regular hourly wages, but was not paid at all. Illinois minimum wage in 2022 was $12 an hour. Thus, at minimum, TRACY should have earned $2,880. $88, sorry. No, it's $2,880, I'm sorry, for 6 weeks worth of work under the IMWL. Now, that's just minimum, as if she would have gotten paid minimum wage, because at minimum, they have to give you minimum wage, but she does have a contractual amount that, of course, is more than that. Okay, so she was at least owed minimum wage, which would have taken her to $2,888 for 6 weeks of work. However, she was paid $0. They didn't care about her bills. Nothing. I don't get it. Okay, thus Thornton Township violated the IMWL. As a direct and approximate result of this unlawful practice, TRACY suffered and continues to suffer wage loss and is therefore entitled to recover unpaid wages, liquidated damages, or prejudgment interest, attorney fees and costs, and such other legal and equitable relief as the court deems proper. And again, she is requesting all of the things before, but I'm still going to read it because certain small things may be changed, like different. Okay, so she is requesting relief in the amount to be more specifically evidenced at trial, representing final compensation to which TRACY is entitled. So she's going to present her true wages earned and not paid but owed. Statutory damages is set forth in the IWPCA. Attorney fees and costs and expenses of litigation and such further relief as this honorable court finds reasonable. I can't wait to see the results of this. I tell you. I tell you. Ooh. Because as we move along to count 8, tortious interference with prospective economic advantage against Henyard, Hunt, and Freeman in their individual capacities. Okay, so this covers what I was about to say next. This lawsuit is them as their professional selves, the authority figures and employers over her, and individually. So now we're getting more specific with individual in count 8 as we move along to page 22. Okay. Now, individually, Robert Hunt. Okay, well, I'm sorry. That's the rest of naming them, okay, individually. All right, and just to be clear, the complaint against the defendants, Tiffany Henyard individually, and Keith Freeman individually, and Robert Hunt individually, for tortious interference with prospective economic advantage and in support thereof, states and alleges as follows. TRACY restates and realleges paragraphs 1 through 116 as through fully set forth therein. When a third party maliciously sticks his nose into the economic relationship between an employee and an employer and cause the employee to lose her job, and that third party is subject to the tort cause of action, even if the employment was at will. Told y'all. Alley versus Shaw, citing Fellhauer versus the City of Geneva. So in another case, Alley versus Shaw, they won using another case, Fellhauer versus City of Geneva, 1991. And this case was won in 2007. Okay. So TRACY had a reasonable expectancy of staying in a valid business relationship with Thornton Township due to her continued employment. Freeman, Hunt, and Henyard had knowledge of this expectancy. Freeman, Hunt, and Henyard intentionally and unjustifiably interfered with this expectancy. Okay. Sorry, let me get y'all up. Okay. They interfered. And they did so by inducting or caused a breach of termination of the expectancy when A. Freeman and Hunt failed to sign off on TRACY's hours and failed to pay TRACY between August 1st, 2022 and September 14th of 2022 and ignored her pleas to be paid. And number 2, Henyard lied. We're not surprised. Henyard lied to the Township Board of Trustees in her quest to terminate TRACY. Tiffany Henyard is what, in her late 20s? Is she? I have to look that up. Isn't she also the first woman, I don't even want to say black anymore because they're using it so much. But is she not the first woman and, of course, first black woman in that position? And this is what she does. But guys, as I will point out in another video, there are many of them. And yes, by them, I do mean black women in power abusing it and having to legally pay the price in important positions. For the life of me, I can't understand why. But it really saddens me on a personal level to know that they would get in these positions and abuse them in these ways. This is very unfortunate. It's just kind of hard to fathom as a woman, full stop, as a woman, how could you, and sleep at night and return and continue and sleep at night. So in this count 8, she's asking back pay in amount to be determined at trial, compensatory and consequential damages, including for emotional distress, punitive damages, prejudgment and post-judgment interest at the highest lawful rate, attorney's fees and costs of this action, and any further relief as the Honorable Court finds reasonable. And we are now on page 23 of 24. Plaintiff requests a jury trial. Okay. Respectfully submitted by Sandra TRACY, by S. Matthew R. Costado. It says one of his attorneys, but if we know about history, we know that it was customary to put his because, well, in the beginning, women didn't even do business, much less have court, hearings or whatnot. So there was never a need to put her, and that was not legally changed. So Miss Sandra TRACY is unfortunately referred to as a his a lot in this document because of that. Okay. One of my midterms in American government, it was, I did a presentation about how eventually women fought for the right to vote legally, but at the time that this was happening, Black women wanted to fight for it as well, because if you guys are familiar, eventually Black men fought for and earned the right to vote, and this it kind of was done because the men felt like it was in their best interest, when they were separating from who was over us before, I forget, France, was it? And becoming the United States of America, and having long battles over this, and not wanting to some states unite because how things are divvied up as far as your representatives locally, that they determine that, and how many citizens you have, how much land you have, things like that, determines how many representatives you get in the big house, right? How many in Congress and stuff like that. And it also has determination over your funding availability, okay, which you can possibly get and you can possibly pitch for. If you want certain fundings or grants and you don't have, like they say, well, you only have this amount of land here, like your state isn't that big and you don't have a lot of accountable citizens, they came to eventually an agreement to count slaves, which was property, considered basically something they owned as cattle or a car or anything else. They that's when they came up with the one force, because it was at the advantage to a lot of southern states that didn't have as many citizens because they were still owning slaves. So these slaves could count to help them when it came time to getting government fundings and grants. So they said, okay, but they're not really humans like us, we'll let you count each as 1/4 of a human. Okay, so the way that they were writing up the Constitution and the laws and things like that, that would eventually, well, subsequently give them voting rights. And I guess once, the slaves started to realize these things and reading and all that, they said, okay, we want to vote. We got to vote. So they did that for a while until they said, okay, you can vote. So then they said, write it down, put it in there, make an amendment. Okay, so that's when we start getting to the 14th, all that. And they said, okay, black men can vote. And women said, excuse me, we still can't vote. How can you give slaves the right to vote and we can't vote? White women, of course. That's when they were fighting to get out there and work and, start to become members of Congress and, other high positions like what Tiffany has, And when they started doing the lobbying, some women in southern states were starting to get amendments placed for their states that they could vote, but not everybody, and it wasn't federally recognized. And they continued to fight and they continued to fight, and eventually they started winning over more states. And black women said, we want to be put in there too. And they was like, no, you don't deserve it. You ain't good enough. You this, you that. I mean, I could really pull up my research, y'all, and it's just it's wild. But yeah, they was like, nah, you can't join this with us. So of course they didn't have enough leverage on their own. So technically, black women still do not have the legal right to vote. I don't know what that fight would look like, but if they wanted to say, you black woman cannot vote, you have no legal right to vote, they would be legal in saying that. That was never changed. It was only amended that the black man, look for yourself, could vote. And I understand that, like, say, in this document, it's saying his. That's something that, I mean, it's up to women if you want to change it. I know we have different pronouns and stuff going on now, but I would want it to be changed because I'm a her, not a he. So respect me as such and address me as such. If I can go to court and I can file a lawsuit, I would like to be recognized as this is a woman filing this lawsuit and not a man. Things have changed. So that's just, it just made me think of that. So this is pretty much the end. The rest is the verification. It says, I, Sandra TRACY, am the plaintiff in this action. I have read the foregoing verified complaint and am familiar with its contents. I declare under penalty and perjury of the laws of the United States that all the factual statements contained in the foregoing are true and accurate. If you know, you know. To the best of my belief and based upon personal knowledge, except where expressly indicated otherwise. Me, being, I guess, petty, I don't know, I would be like, why is it saying his? And the attorney probably would be like, oh, that's just something that never got amended. It's just a generalization. Whatever he would say, right? Something probably like that. No worries, it still means it's referring to you. And then I would be like, well, technically no, because it's saying his. I'm saying her, because I'm a she. My name is listed, and it is referring to a woman. Could this be a technicality used against me? Legally, I'm going to say yes, because it is not accurate to whom the plaintiff is. Okay, just like a search warrant or something can get thrown out, or a case can get thrown out for a technicality. This would be a technicality. But again, being petty, are we gonna cross this out, initial it, and put her? How are we gonna handle this? How can we change it? Oh, we have to change where it is written that you are addressing everybody as a he. So that would be a big change that needs to be made, right, for this to be able to be changed legally, I'm assuming. And, people will be like, why are you being petty? It's not that big. Well, I don't know. Because if other people, and that could be whomever, even me, if I decide I want to be called, what are some pronouns? He, them, they, thou art. How grateful? I don't know. It's all kind of stuff that people can refer to themselves as, and it is demanded that it's respected. If all that can take place, then you surely can refer to me as a she if I'm telling you I'm a she and I'm not a he. So, I don't know. Just a petty moment. So, that is the end of this lawsuit, guys. And this was filed in March, of this year. It is April. I saw no updates as far as it going to court. I'm pretty sure it's going to take some time. Now, one thing I wanted to say about this before we move on to another video with other court cases and situations is, hold on one second. Okay, so right here, this is ABC Eyewitness News, posted on March 14th, and it says 3 former employees sue Dolton Mayor Tiffany Henyard for wrongful firing amid corruption accusations. Okay, so in the suit that we just read, she listed quite a few people, and I'm pretty sure 3 of those people are going to be here. Let's see what they say in this news. We're probably going to get a commercial. Well, they're just going to say what I'm about to read, so we don't need to play that. But look at Tiffany. I'm trying to make sure it don't play. Okay. All right. So it says 3 people are suing Dolton Mayor Tiffany Henyard after they said they were wrongfully fired. All of them said they were terminated for refusing to do political work for Henyard. The way she treated me and other people was wrong, said Samshaya. I'm sorry if I'm saying this incorrectly, which I probably am. Samisha Williams, former director of building permits and licenses. Okay, so I recognize that name mentioned in the suit. Williams, former human resource manager for Thornton Township, Sandra. And former Dolton Public Works Department Administrative Assistant Karen Johnson have all filed lawsuits. These 3 cases are all based around the same premises. They are wrongful terminations at the hands of Mayor Henyard and her administrations, said attorney Matthew Costardo. All 3 former employees said that they were fired at some point near the end of 2022. Williams said the workplace environment worsened about a year before that, starting with the mayor asking her to do things that were unethical. So just imagine how many people she asked and they obliged. I'm sorry. It was just some side stories that caught my attention. Oh my goodness. Um, so withholding building permits and businesses licensed to people that didn't donate to her campaign or just people she didn't like in general, Williams said. Williams said she continued to raise concerns about these requests with the mayor, but was later moved to the water department before eventually getting fired. This is another opportunity for me to point out that I don't agree with the employees being, I don't know if I want to use the word harassed, but made to feel uncomfortable or as if they are guilty simply because they are an employee by mainly people from out of town. It seemed like a lot of people in the meeting and some commentators felt like, well, this comes with the job, or you're part of the mess, or what have you. I know we all don't really think like this, because that can't, like, say the woman who stood up and said, I feel afraid, I don't do politics, I'm just an employee, I'm trying to serve, blah, blah, blah. We all may have our opinion about her saying, I don't got nothing to do with politics, I don't want to have nothing to do with politics, I'm just here to serve. But again, that is your opinion, and we don't have a right to enforce on this woman that she get involved with the politics. No matter how bad things are, everybody ain't for the same reasons. We're not all here to perform the same actions or for the same fight. It's okay for some people to serve in other ways and not all be down for everything you're willing to be go up against. Why can't she, I think she work with the seniors, why can't she be of service without getting into the other stuff? But it doesn't mean that the camera should be in their faces. They should feel, because if you know Tiffany isn't gonna see you, she's not gonna see you. What's harassing the employees gonna do? Putting them on camera and stuff like that. When you read this and this woman says, okay, there's a lot of things that they were asking me to do which goes against other citizens, and I standing up for what I don't want to be involved in, which I'm also standing up for the employees that could potentially be harmed by these actions. I'm refusing. So you're getting demoted and then fired. So you don't know what their fights are. You don't know what their fights look like outside of what they're saying or able to say, or afraid of retaliation for saying, and they probably already want foot out the door. Like, people talk junk about the woman that said I quit that day. We don't even know if it's her that's in this lawsuit. You understand? Like, we do not know if it's the same scenario. She was demoted or at risk because she might have said something. And another employee was like, yeah, Tiffany, she over there is talking about you. She said it ain't right the way you doing other people and da-da-da-da. Or anything. Your job is your job. It pays your bills. And you have a right to it. It is a small town. But we don't know what their positions are, their fight is. What I can say, which should make sense to everybody, is if they were truly down, I don't think you would be seeing them on the front. I think they'll be somewhere getting paid in the shade like some of the others. Okay, not working probably a minimum wage or a slightly above minimum wage position. They'll probably have all kind of kickbacks and all that. and be the first one to tell you, get and that camera up out of here. I mean, even though they probably already kind of saying that, but you understand what I'm saying. Like, they'll be like, leave Tiffany alone. First, I fight you. But I mean, I know y'all get what I'm saying. I don't think it's right. We are supposed to be advocating on behalf of the people there, because technically, in my opinion, most of us are part of that. We just don't know it because we don't check our own situations, right? So Dolton is really representative of a lot of places. You'll find out if you want to, or if you need to. So to go on and finish reading, she says, I was the only person at that time in the department who knew how to process business licenses, but they moved me to the water department anyway. After a complaint in the lawsuit on behalf of Johnson claims that she was intentionally treated differently from other similarly suited employees, and there was no rational basis for the difference in treatment. The lawsuit also states that Henyard restricted certain village and/or township employees' access to the village and/or township buildings. We did a mock trial to practice muting the trustees because she didn't want the trustees to have a voice, Williams said. In her words, she was at war with the trustees. Do you guys, when y'all say they muted their mics, couldn't this be what she's talking about? You know how brave it is for these people to come forward with this information? Small town, they live there. Pretty much everybody of power is corrupt. And they are clearly retaliating. We just read about somebody getting actual bullets in their car and house. Businesses are getting shut down. People are not getting paid. They got bills. And they have high taxes because, again, it's a small town. And look who getting all that money, and what in the world are they doing with the money? They're not only having high salaries, but they smuggling money. What's really going on? What are they going to do when it calls for paying it back? I mean, they're leaving the town in debt and all that. It's just, it's a lot. Okay. So it says, the mock trial, one of the former employees is hoping to get her job back from the lawsuit, while the other two are just hoping to move forward. As they say, this has caused them emotional and financial damages. Well, I can see wanting your job back. That's for sure, especially if you like what you do and you've done it for so long and you didn't really have any intentions on doing anything else, and the town really doesn't have much else to offer. And plus, the ones that's there that cause it, they probably gonna be out of there anyway. So yeah. So she says, I didn't want to file it first, but it didn't sit right with me to do nothing, said Williams. Honestly, guys, these people should be supported and uplifted, not feeling some kind of way with cameras all in their faces and, oh, where's Tiffany and blah, 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 you know. So a court date is still being decided for the lawsuits, and Henyard, who is also Thornton Township supervisor, is embroiled in a corruption scandal and has been accused of using village money for personal reasons. I mean, she show up to meetings looking like she about to go do a concert, like she Tony Braxton or Tamar Braxton or Beyonce or somebody. Like, what's all with the stage makeup and do-up? It's excessive. She's not a burn victim or something. She don't need all that glamour to be attractive or presentable. It's giving superstar vibes. But anyway, she's just blatantly out here with her mess. I don't know. I just don't understand why she doing dark skin sister too. Come on, Tiff. Come on, sis. Come on. Okay, so Henyard, who is also Thornton Township supervisor, is embroiled in a corruption scandal. And okay, I read that. ABC 7 has reached out to the village of Dolton, Henyard's office, and the village trustees for a comment and has not heard back yet. Do not hold your breath. So that concludes everything that I have for this particular situation. Coming up next, all right, in the next video, I'm going to be addressing Keith Freeman, but he is going to get more than one video. Okay, there are a couple of different things to address with this guy. And of course, he is the first official indictment. So now we can say Mimi in the Trap is going down. Because now it's definitely starting to go down. Yeah. Yeah. I think I got one. I'm going to put these two together in one video on Tiffany. Just a couple of different other issues that I want to address. So let's see what we got so far. We got one other on Tiffany. I'm trying to keep on these an hour or less. And for Keith Freeman, it's going to be at least two. Okay, at least two. And we'll see moving forward. Okay? All right. And I will have the documents for his indictment and everything to read, just like I read this one. All right. So I will see y'all in the next video. Leave your comments below. Any audio problems that you can detect or any other issues. All right. And if you say less commentary, I think I did pretty good on this one, but it's kind of hard not to say anything. But because the documents are so long and everything, I'm just trying to like just read them really. And yeah. Any type of requests or, you know, constructive, respectful criticism. Yeah, we can do that, right? Yes, we can. Yes, we can. All right. So, I'll see you guys in the next video. But guys, please hit that like. Please leave a comment and please share the video. Thank you so much. Holla.